So in a post-Tuesday reality, we still have the lingering New York criminal conviction of Donald Trump out there, specifically his sentencing. I'm Dina Dahl. We're on the Legal AF channel. Karen and I are going to get into this. As you know, Karen was like one of the lead analysis throughout the whole trial in May. And this sentencing is important. And it is the one last kind of like crucial piece, I guess you could say, on the conviction. So we're going to get into it. What do you think, Karen? We have an immunity decision by Justice Maran next week, and then a sentencing.
Yeah, so as you know, I used to work at the Manhattan DA's office for 3 decades. I was a prosecutor there, and my final position was the chief assistant DA, which is the number two under Cy Vance, not Alvin Bragg, the current DA. So I've never worked for him. And yeah, so it's definitely something that we should think about because there are a lot of possibilities about what's going to happen. So just to remind everyone where we are, he was convicted of 34 felonies down the whole line of the jury form, right? Every single one he was convicted of, every charge. They were Class E felonies, which in New York is the lowest level felony, but he has 34 convictions. And so there's two things that are left. There's a motion that his lawyers have made on presidential immunity and sentencing, and both things have to be addressed between now and November 26th. And so now that he has won the presidency and he's going to assume office, what's going to happen to both? So let's start with the presidential immunity motion. So the reason that's coming up now is because when he was convicted in May, in July, that's when the Supreme Court came down with the new decision creating this brand new law that never existed before, presidential immunity in the criminal context. And what they said, though, was not only is the president immune for his official acts when he is president, and that people say, okay, then why does that apply to this? Because there's a federal judge who's already ruled twice, Judge Alvin Hellerstein in the Southern District of New York, when Trump tried to remove the case to federal court. Judge Hellerstein has said this was personal. This was not presidential. The conduct is personal. This is you paid a private porn star through your private lawyer, and this is personal, not part of your presidential duties. So therefore, it's not going to be removed to federal court. And therefore, presidential immunity for the conduct won't apply. I'm just adding that second piece to it. So why are we here? We're here because the Supreme Court created a second category of impermissible evidence that can come in at even a case where he's not immune from the charges. You can't bring evidence in that comes from his core presidential conduct, his duties, his and things like that. And there was some evidence. It was commingled, right? Because don't forget, the trial extended into his presidency into the time period of his presidency, because he wrote the checks that paid Michael Cohen back during his presidency. And so there were witnesses like Hope Hicks, for example, who testified, who was working at the White House. And that evidence was really crucial. And the prosecutor there summed up in their summation, Josh Steinglass, who's somebody I know really well, he's an excellent trial lawyer. One of the things he said was, look, Michael Cohen, you don't have to just believe Michael Cohen. There's lots of corroboration, and specifically pointed to Hope Hicks' testimony. And so the judge has to make a ruling on what evidence in particular is evidence that this new immunity ruling applies to, and then what is that impact on the case? Is it harmless error, or is it something that requires reversal? And both things are possible. I think it's going to be harmless error because there was such a mountain of evidence, but he could reverse the conviction and order a new trial. Now, if he does that, obviously it's not happening for 4 more years, if at all. So that's a big deal. The second
Right.
thing that might happen, go ahead.
Yeah, well, I mean, and I think though that another option, and maybe this is what you're about to lead into, is that it's seen as private conduct. I mean, you can have private conduct even in the Oval Office, aka Bill Clinton,
Of course.
right? And so it's not even an harmless error. It just not wasn't even an error to admit it,
Correct.
right? And
That's
and
true
I
too.
I and I because I think to say that just because he used government resources the desk, let's say, to sign the check and spoke to his, yes, an aide, but clearly about a private matter. I think Justice Merchan will say that that's private conduct. Whether or not it at some point gets appealed and that Supreme Court, like pro-Trump group denies it, like reverses that and says, oh no, this was at least quasi government and kind of like the fruit of the poisonous tree, it shouldn't be allowed. I could see the Supreme Court saying that more than Justice Merchan. To me, he has his head screwed on straight, and I think he's going to see this as private conduct.
Yeah, look, Judge Merchan is a very down the middle judge. He is not a people's judge. He's not a defense judge. He's a calling balls and strikes as he sees them kind of judge. It's one of the reasons I really thought the attacks on him were incredibly unfair and unreasonable. To call him biased, I've seen biased judges. He's not one of them. So that was a really shocking and offensive to people who practice there and know him as a public servant. But what I was going to say, in addition to it, the excellent point you just made, because you're right, he could rule that for sure, is let's say he either rules that it's private conduct, the evidence was private and not presidential, and therefore it was admissible, or he says, well, even if it was harmless. Let's say he doesn't reverse the conviction. Okay, what happens next? Does he go to sentencing November 26th? Or what's more likely, I think, is Trump will run to the appellate courts and say he will seek an emergency stay because it is unclear whether this is something that they can appeal in right now, or if they have to appeal later after he's sentenced, right? Because we do know the Supreme Court did say that you can do this intermediary appeal before a final conviction of the presidential immunity issue. That's what's happening right now in Washington, D.C., in the case before Tanya Chutkan. Does that apply just to charges, or does that also apply to evidence? That is uncharted territory and unclear, and the Supreme Court didn't make it clear. So I don't know whether Judge Merchan will say, you know what, I'm going to give the president an opportunity to appeal, or if he's going to issue a stay of the sentence while he appeals. So, or if he says, forget it, we're going to move and proceed with sentencing. So if they proceed with sentencing November 26th, what will happen at the sentencing? The judge has very limited options because he's about to take office. He cannot do anything that will interfere with his ability to be president of the United States. So if he were to sentence him to jail, for example, it would have to be a very short period of time, if at all. Trump could make the argument that part of his duties is to prepare to be president, and he can't be incarcerated. And I don't think a state court judge, because of the supremacy clause of the United States Constitution, can interfere with an Article 2 of the Constitution duties of a future or current president. So I think jail is probably off the table completely. Same thing with probation. I don't think he'll have any ability to have any supervision over somebody who will be president of the United States, just given his role in the Constitution. So I think you're going to see, if he is sentenced, something very like community service or a fine. That's what I see. That's what I see happening. I know it's not the outcome anyone wanted, but the bright side is if he is sentenced, he will be a convicted felon, because he is convicted after trial, but a conviction in New York is after you're sentenced. You are considered a convicted felon for all purposes. So we'll see what happens, but those are the possibilities. I stand by my old office. I'm proud of them. They are the only ones who could get their case across the finish line. A lot of people were poo-pooing it, saying, why this case? It's not as serious as the others. And I love that the prosecutors there put their head down and did their job and did what they've been doing for decades. Manhattan DA's office has a great reputation, and I'm glad I spent my career there.
Absolutely. Yeah. A few things on what you said, but completely agree. They did their job. They did an amazing trial, got the conviction. In terms of the interlocutory appeal, that is an interesting one. I think that if the trial hadn't even started yet, obviously the immunity issues would have been decided first, like you said, in January 6th. Now it's at a weird stage, though, because evidence, contesting whether or not evidence basically was properly admitted at court is always something that would be dealt with after sentencing in a typical appeal. So talk about not enough guidance in the Supreme Court here, because if you were to take it, I think, as a more typical situation, you would say that this would not be something he'd be able to appeal with until it was final, because evidence in general, there's going to be other types of evidence issues he's going to be able to appeal, right? In terms of like how much Stormy Daniels was able to testify about her sexual encounter. That's going to be on appeal. Like, did the judge give him too much leeway to go in? So this idea of whether or not Hope Hicks was supposed to testify or not, you would normally see during an appeal. So yeah, that one is a little bit harder. I think that he's going to decide private conduct personally, because I just think that that's the right way to go. And I think he's not going to allow him to appeal it in between, because at this point, it's already been done. It's already been in court. I think that usually you allow those kind of interlocutory appeals because you're trying to prevent a miscarriage of justice. You're trying to, if somebody has immunity, they shouldn't go through the whole criminal process. They shouldn't have to hire a lawyer. And so you're allowing them to bring that up first, to be able to have the case dismissed if it needs to be dismissed. We've already done the deed is already, the cake has been baked, as they say, right? He's already gone through it all. So to me, there's just not even as much of a justice need for him to have this decided before sentencing. Like, the trials happen at this point anyway. But what about, do you think in terms of just, because we're in this completely uncharted territory, obviously no president-elect has ever been in a sentencing before. Will we see Trump ask for a postponement of the sentencing? Would the DA want that? Like, to your point of it being final, maybe they wouldn't. And it doesn't probably even matter at this point. He would probably, where they say, hey, no, we would rather sentence him after his 4 years, because then maybe he could get probation. I mean, do you think that there's do you think it will happen on the 26th, or is there any possibility that there will be just a postponement?
Look, I think if you survive the immunity and he doesn't get a stay by an appellate court or by the federal courts, I think the DA, everybody wants this to be done. I mean, this sentencing will proceed if we can get past the immunity hurdle and the case is not stayed so that he could appeal interlocutorily along the way. Yeah, I don't think the prosecution would ask for an adjournment of 4 years. So much could happen during that time, including a new Manhattan DA, including the people who are there. I mean, no, the time is now, even if it's going to be a sentence that we will potentially think is different and unfair, because anyone else who's been held in contempt 10 times, threatened the judge, threatened the DA, convicted of 34 counts, they had to find that this was election related, right? That he essentially stole the election by suppressing this evidence potentially. It's a big deal. It's a serious case. Normally, this would be, I would have said if he lost the election, he'd be going to jail. And certainly the government, or the prosecution, would be asking for jail or prison for sure. I don't know that for inside information. I'm just telling you what my thoughts are and my judgment is. And I think the judge would have considered it strongly and potentially even potentially sentenced him to jail or prison. But I think that's off the table now. But they will want to sentence him. It is going to be frustrating because it's going to be, I think, it's going to feel like a slap on the wrist. But he'll be a convicted felon, first time ever in the history of our nation.
Yeah, and that can never be taken away. And it will always be in the history books. Those transcripts will always be in the history books. And that's going to always be an asterisk on his name. Just really quickly, what do you said that he won't even be able to get probation. I mean, is that because you think the judge is just going to be unwilling to give?
No, because probation is No, because probation is a supervisorial hold on someone. And I don't think the supremacy clause would allow a state court to impose something that could potentially
Mm.
put a requirement on the president of the United States. Probation would be for 3 years, right? That's how long it takes. There's no way that if that a probation officer could say, you have to check in at this time, you have to report this, you can't have any, it's preposterous. He
Mhm.
can't do anything. They can't do anything. There's no point to put him on probation, and I think it would actually be illegal because of the supremacy clause. Supremacy clause is real, and as a state court
Mhm.
prosecutor, we were fully aware of it at all
Mhm.
times.
Mhm. But like everything, it's new, right? I mean, this is unprecedented, as they say, because the fact that he could even, I mean, normally we would never even be in this situation because pretty much every other situation, for him to be a felon and still be able to be a president and alone is unusual. But yeah, it just seems wrong on many levels. But all right, this is what we're going to have to.
So much of what's happening right now seems wrong on so many levels. That's what I
So
will
many
say.
levels. But like we said, he still got the transcript. He still has the conviction, and he will be sentenced.
Yep.
Yeah,
Hopefully.
yeah.
Hopefully. Depends on this. The Supreme Court gave him a gift, this immunity decision, and we'll see how it impacts it. The Judge Merchan said he's going to make a ruling on immunity and, if still necessary, sentence. I mean, Judge Merchan is signaling to the world that he does not know how he's ruling, and he's going to take this very seriously, and he's going to apply this new law to the facts and see. And so we'll see next week if the sentencing is going forward. But if he can get past that, and Trump doesn't successfully get an appellate court to stay or stop or pause the sentencing while he appeals all the way up to the Supreme Court, whatever Judge Merchan's immunity decision is, then he will be sentenced on the 26th.
Well, we will be sure to recap both next week, the immunity decision, any outcomes there, and hopefully the sentencing does go forward. Even if it's not what we like, he should get sentenced just like every other convicted felon out there.
That's
So,
what's so atrocious is every other person who is out there gets treated so differently than he gets treated,
mhm,
and justice is not blind. He gets away with things that nobody else would ever get away with.
mhm,
And he's going to be president. So,
mhm, mhm.
but it's great seeing you, Dina. I hope we
Thanks
do more of these duets together.
for sure. So free subscribe to the Legal AF channel. Even more in what is to come, lots of chaos will give clarity on all the different legal developments that are sure to come.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.